This is TWiT.
Mike, when you arrived, you said, breaking news, the Texas Appeals Court, the 5th District, has ruled that the Texas social media law can proceed. A lower court had blocked it. That injunction has been lifted. The panel stayed a district court injunction that had paused the law while judges consider an appeal of the lower court's move. The decision was which was supported by only by 2 unnamed judges, nor did they immediately publish their reasoning.
You presume there is any.
According to protocol, it came after a Monday hearing when the jurists appeared to struggle with basic tech concepts, including whether Twitter counts as a website.
It was pathetic.
It was bad.
So what, Mike, what is the, just out of curiosity, the social media law in Texas?
It has a few different components, and I don't think any of them are actually constitutional. If we had a Fifth Circuit that wasn't crazy, where it requires some element of transparency in terms of how social media websites handle content moderation. They have to publish certain rules. There has to be an appeals process, and you have to explain every decision more or less.
Oh my God!
And if people feel that the explanations are not, up to, whatever level, they can complain, and the Attorney General of Texas can take action against the websites. It's effectively, trying to restrict the social media website's ability to do any kind of content moderation, especially obviously the kind of content moderation that the current political class in Texas does not like, which means anyone who supports Donald Trump or Greg Abbott. And so, they're basically going to be able to sue different social media platforms, and they will do so.
It sounds like the Florida law minus the exemption for Disney.
It is very similar. There are a few very minor changes that doesn't really make a difference. They're very, very similar laws. Florida's law, so both laws were passed, and both laws were then it was sued to block them, and in both cases the district court stopped them
because of the First freaking Amendment, right?
Mainly because of the First Amendment. And then there was an appeals hearing for the Florida law about 2 weeks before the Texas one, but we haven't had the ruling. And the hearing it's the 11th Circuit for the Florida law. The hearing there went really well, and the judges seemed to really get it and seemed very, very skeptical of Florida's argument, as opposed to the hearing in Texas, where the judges seemed to have absolutely no clue. It was all over the map.
Website?
They were asking,
what's a website?
Oh my God.
Yeah, it was, and just all of the comparisons were weird. They didn't understand Section 230. They didn't seem to understand the First Amendment. And so then,
That's $1,000 handshakes right there, man. That's all it is. $1,000 handshakes.
I mean, and then this is 2 days after the hearing. I mean, they didn't even wait. Florida is still sort of, probably coming up with their written opinion on this, whereas the Texas, they just put out this announcement saying that they've lifted the injunction and the law goes into effect immediately, and they'll give out their opinion at some later date. And so it's going to be a mess. And if I were running a social media company right now, I would be talking to my lawyers this very second, trying to figure out if we can still do business in Texas, because I think it's extraordinarily risky to have any users in Texas right now if you meet the qualifications of this particular.
Well, now I'm nervous because TWiT runs a Mastodon instance, twit.social. Forums would count, right? We run our own forums on Discourse. At twit.community. Does a chat room count? We've got chat rooms, sure, and we've got users in Texas. So you're not giving me legal advice, Mike, but are lawyers all over the country telling social networks don't allow Texas users?
It's possible. I forget the exact details, but because there have been so many of these kinds of laws, I forget the exact thresholds. There may be some thresholds in terms of size. For the Texas law, I'm sort of pulling it up in the background here. So I don't remember what the thresholds are.
Because if we're small enough, that might not be an issue.
If you're small enough, you might be okay. But
because these are really aimed at Twitter banning Donald Trump, really. Let's be honest.
Yeah, that's exactly what it's used for. But to be clear, that doesn't mean it doesn't affect you, right? I mean, you use
50 million
Twitter.
monthly users or more, so we're out of the dark on that one.
By a hair.
By a hair.
But who knows, right? I mean, next month you might hit that number. You don't know. And but it does also impact the services that you use. You guys use YouTube, you use Twitter, you use Facebook to promote stuff. You use Discord, and all of these services may be impacted by this, and it may actually limit your ability to communicate with people in Texas, for example.
The Texas argument was that social media is a common carrier, and they want social media to carry all content unmoderated the way a phone company is expected to carry all calls. That means zero content moderation.
That'll be such fun.
It's the whole common carrier thing really frustrates me because if you understand what a common carrier is, just by its very name, right? The idea is you are carrying something from point A to point B. And, historically that might be people or cargo, and then it became, data or voice. But like social media is hosting something perpetually, right? It's not just about getting from point A to point B. And the idea that
it's not ephemeral phone calls.
Right. The idea that you should be forced to leave up content in perpetuity, that may be harmful or otherwise problematic or harassing. There are all sorts of issues with it, and so the push to declare social media common carriers is really, really bizarre, and it's especially bizarre because the very same people who are strongly pushing to declare social media common carriers absolutely freaked out and spent years complaining about attempts to make broadband carriers common carriers, where there's a much stronger argument. This is the net neutrality debate, right? There's a much stronger argument that a broadband player should be covered by net neutrality, that they should be a common carrier. They are point A to point B.
Isn't it hysterical how they don't want ISPs to be common carriers, but they do want Twitter to be a common carrier? Completely, they're reversing the meaning of common carrier. In effect.
Yes, it is. One of them actually makes sense as a common carrier, and one of them doesn't, and they have it reversed. And in fact, I forget which bill, because there have been so many of these bills. I don't remember if the Texas bill has this, but some of these bills have explicit language that says this cannot apply to a broadband provider. So you can tell that AT&T and Comcast lobbyists went in and said, okay, this is fine as long as you have this line. Kind of like Disney lobbyists in Florida saying, like, add in the theme park exemption until we've pissed off DeSantis, and then
now they're going to take it out, right? Yeah, let's remove it now. It's just essentially using these laws and these courts to espouse a political point of view, having nothing to do with the reality of the nature of the nature.
Well, it's
really depressing because
it's a position of victimhood.
But this is what you're seeing. This is what you saw with Roe v. Wade. They couldn't get the legislature, they couldn't get the voters to overturn it, so they went the judicial route, bypassing legislatures. This is a useful route to go to go to judges.
Back them,
yeah. And in this case, this is a law that was obviously passed by the Texas legislature, but it's, obvious. I mean, I'm not a lawyer, but I mean, I do think the First Amendment says the government shall make no law infringing free speech. That's exactly what this is, isn't it? Or
Mike,
no?
Can I ask two questions?
Yeah.
First, I can't, like you, I can't keep all the laws straight. Is this law like the abortion law, that it doesn't so much has government step in, but allows citizens to sue?
If I remember correctly, and again, there are different laws, so I don't remember all of them. I think the Texas law only allows users to complain. The only one who can actually enforce it is the Attorney General. So the Attorney General can then bring suit on behalf of residents of Texas who complain. I think that's what it is. I don't remember the details. And again, a lot of these have
HB number 20, an act relating to censorship of or certain other interference with digital expression, including expression on social media platforms or through electronic mail messages. Okay.
What?
So, well, and again, email, common carrier, a little different than social media. The idea is that regardless of the position you state, you should be allowed to say it, which I don't disagree with. Some have said.
Well, but don't
number
forget,
have
there's
said,
also a right of the company to not have to carry things.
and that's why the free speech thing is
not
interesting.
free speech.
That's why the free speech thing is interesting. They're saying, well, it's the free speech of the people posting. And we're saying, well, yeah, but you can't abridge the right of Twitter or any other company to moderate. That's
right. Think of it this
email
way.
is a common carrier.
yeah. I
Email
would
is
say
a common
I would
carrier,
say email-
considering that somebody manages the servers and stuff the same way they're managing all of our social media. Because I'm sure a vast majority of users aren't like you, Mr. Laporte, hosting your own mail server and things like that. So email is exempt from this.
Yeah, I don't know what the email part is, but just to clarify, like
It sounds like they just threw that in. You know,
I'm sure some email provider required something, but the the way to think of it is, instead of when we talk about content moderation, just think of editorial discretion, because that's what it is, right? This is content that you're hosting on your website. You have editorial discretion over it. Free speech is about your right to speak, which you still have your right to speak. It doesn't mean you get to commandeer somebody else's property in order to do that. I can't put up political signs in your front yard because it's your property, right? If I want to put signs in my front yard, that's fine. If I want to set up my own website and post stuff, nobody can stop me from doing that. But I can't commandeer somebody else's website to post. And yet this law is effectively saying, yes, effectively the state can commandeer private property and force postings there. And when you think about it that way, it feels like it goes against everything that
it's like being forced to put somebody can put a lawn sign on my lawn and I have no choice in it.
Right, because you can't discriminate. That's basically the argument. Saying that I can't put the sign for the politicians I want in your yard is a discrimination issue. But
the larger thing going on here. Sorry, the larger thing going on here is this idea of victimhood. It's the whole cancel culture BS. That and it fits right into Musk, which we'll get to in a few minutes. Which we'll also have to give Mike his blood pressure medication when we get to. Where it's a weird phrasing now. Is basically anybody can say absolutely anything, and if you restrict that in any way because you have standards, then you're going to be accused of canceling, and then I, the speaker of this obnoxious speech, am the victim, and so it's a weird way to turn white people into victims all the time. Yeah, sigh.